Of the Subcommittee on Intellectual Property Competition and the Internet on the Internet Radio Freedom Act will come to order. The title of today's hearing is Music Licensing Part 1, Legislation in the 112th Congress. The focus of the discussion today will be legislation introduced by Congressman Jason Chaffetz, H.R. 6480, the Internet Radio Freedom Act. Today's hearing is the first in what I hope will be a series of hearings examining the nuances of music licensing. The Merriam-Webster Dictionary defines the word system in a number of ways. One of those is a harmonious arrangement or pattern. I'm not sure that definition is the one most suitable to describe the accumulation of laws and customs that govern the music licensing apparatus in the United States today. The complexity of our music licensing system is a result of a number of sometimes independent but often interdependent factors. For instance, there are distinctions that are based on, one, the type of work, whether the work is a musical composition or sound recording; two, the type of right someone wishes to license, whether they want to distribute, reproduce, or publicly perform the work; and even three, the type of technology they plan to use, whether they want to publicly perform the work by means of an analog radio or internet radio broadcast. To be sure, there is often a need for fine distinctions in a subject area as complex and far-reaching as copyright law. And much of our work in this area is frequently devoted to examining how best to calibrate the law to ensure it achieves the right balance in a particular area. But from time to time, we need to step back from the pieces and look at how they fit into the whole. Music licensing is an area where it would benefit us to take a broader look. To their credit, under the leadership of Chairman Sensenbrenner, Conyers, and Smith, this committee began the process of seeking to modernize and bring some order to aspects of our music licensing system that have been slow to adapt. Indeed, 4 laws that originated in the subcommittee that relate principally to or profoundly affect aspects of our music licensing system were enacted during the last decade. And the committee and the subcommittee devoted considerable effort to attempt to both resolve the long-standing debate over whether the United States should recognize a full performance right in sound recordings and modernize provisions in the Copyright Act that relate to the collective licensing of musical works. But there are many interconnected issues that have been raised by stakeholders on all sides that the subcommittee needs to begin to carefully review and consider. These include the following. First, Representative Chaffetz and webcasters have raised the issues of rate standard parity in the Sound Recording Compulsory License, Section 114, and reform the adjudicatory and rate-setting processes. Second, sound recording stakeholders have raised the issue of applying the sound recording statutory license to terrestrial radio stations. This committee reported a bill on that issue in 2009. Third, music publishers and webcasters have raised the issue of the rate standard in the Musical Works Statutory License, Section 115, and suggested a need for parity of that standard across licenses. They have also raised the issue of reforming the Musical Works License, especially as it applies to use by digital services directly. Fourth, performing rights organizations that represent songwriters and publishers, such as ASCAP, have asked the committee to examine broadly issues of music licensing, including current decisions by the Rate Court in New York and the continued utility of the consent decree. Fifth, some broadcasters have suggested that performing rights organizations that currently operate in the free market, such as CSAC, should be bound by a consent decree or legislation in a manner similar to that which binds their competitors, ASCAP and BMI. All of these issues need to be carefully examined as they all affect both the incentive to create new works for consumers to enjoy and innovation in the music and internet industries. However, today we focus our attention on the Internet Radio Freedom Act. This legislation seeks to harmonize the rate-setting standard among Internet radio broadcasters and satellite and cable radio broadcasters by changing the rate-setting standard from the willing buyer, willing seller standard to a modified 801B standard similar to what cable and satellite radio broadcasters currently operate under. It is worth noting that this legislation does not attempt to address the question of whether terrestrial radio should pay performance royalties. In addition to harmonizing the rate standard, H.R. 6840 also contains numerous other provisions amending the procedures governing the music licensing, including changing the method by which copyright royalty judges are chosen. I am open to the idea of harmonizing the rate-setting standard to create more parity across music delivery platforms, but I am also concerned about ensuring that those who create and perform music are fairly compensated for their creative works. I hope today we will have a productive conversation about the issues, including, 1, whether we should harmonize the rate standard at all, 2, if so, whether the 801B standard, the willing buyer, willing seller standard, is something in between is the right balance, and 3, how adjusting the standard would affect innovation in the Internet radio market and compensation for artists in the long term. The need to protect intellectual property and the imperative to foster innovation are not mutually exclusive goals. We can and will promote both interests going forward. When we succeed, hopefully more of us will also agree that the copyright law in general and the music licensing system in particular resemble that harmonious arrangement or pattern defined in Merriam-Webster's dictionary. I look forward to hearing the testimony of all of our expert witnesses today.